I'm Rachel Davison Humphreys with the Bill of Rights Institute. Citizenship is hard work, and BRI is here to help. So every week we have what's happening in civics, history, and at BRI here on our YouTube, Twitter, and Facebook streaming. We want to hear from you, your questions. So go to Twitter, Facebook, and YouTube. Let us know what you're thinking. This week, we are here to talk to you about a lesser known part of the Supreme Court, the shadow docket. It's been in the news a lot lately, and we wanted to give an opportunity to talk about what the shadow docket is, how it affects policy in the US, and what resources BRI has to help you think about the Supreme Court more generally. Today, for the first time ever, I have a guest, and I am joined by my very dear colleague, Liz Evans, our regional programs manager, but also an education leader in her home state of Arizona. She's a self-identified Supreme Court nerd and is an absolute wealth of knowledge and has tons of great resources about teaching AP government on her personal site, lizevansmbct.com. So Liz, thank you for being here so early this morning.
Thank you. I'm excited to talk about this. You know how much I love talking about this stuff.
Yeah, I saw on Friday, we had our Constitution Day live event, and I saw you wearing your dissent collar. So I was paying attention. Go ahead. How do cases usually go through the court? Let's talk about that first. And then what is the shadow docket and how is it different?
Great question. So usually when a case goes through the Supreme Court, it's been years in the system. Take, for example, the recent student free speech case. She is now in college, and that just got decided this year, but it tends to be decided and go through an appellate court, and both sides get time in front of the justices. There's longer periods of deliberation and discussion before opinions are even given. Those opinions are authored, they're signed, who thinks what. And it's just a longer, more deliberative process. Now, the shadow docket is something a little different. So there have been in times past, the court goes from October to generally June. Essentially what happens kind of in those summer months is if there is a case that an applicant can say there is irreparable harm if it doesn't get stopped, usually a death penalty case. So it's not that the Supreme Court stops the death penalty from happening, they just prevent it at that time. Essentially, though, that's emergency cases, they're emergency relief. What we're seeing a lot this year is more cases. So this year we saw the eviction moratorium. And again, the Supreme Court is not making a ruling. They're just saying whether or not you can continue to do it or not. There was immigration policy, and then most recently, the abortion law in Texas. The thing with the shadow docket that's a little bit weird is it usually is a quick turnaround period. So we're talking hours instead of years, 72 hours where the court is looking at something and deciding whether or not they can continue on with that law or whether we need to stop it. The important thing with Texas is they just said that the law can continue. They actually are hearing a case, I believe, from Mississippi this next term. The decisions are quick. They're usually not signed, and it's not the normal transparency we're used to seeing with the Supreme Court. And these are the shadow docket is a really powerful tool that affects public policy without us actually hearing explanations for it, which is not something we're used to with the Supreme Court. So it's a part of the Supreme Court that's important, again, when we're looking at death penalty cases and people want to have their case heard or have an appeal. But other than that, it usually isn't used. This year, it has been kind of on fire.
And that has big implications for our democratic processes, right? Like there are real concerns about checks and balances when you have things not going through the normal kind of civic channels, right? So how does the shadow docket affect checks and balances?
So it's really interesting because there's been two different things this year. The House Subcommittee on Courts, Intellectual Property, and the Internet actually had a hearing on the shadow docket. in February, and they talk to scholars, they talk to all of these people, because in committee hearings, they're gathering information. Congress, is what funds the Supreme Court. The Supreme Court, they're not elected, but there's still many checks and balances. And then in April, President Biden created the Supreme Court Commission. So it's worth noting that Article 3 itself is really short and doesn't give us a lot of information. So it's been interpreted the 200 plus years that the Supreme Court has been, working. And it doesn't give us a lot of direction. So we rely on Congress and the president and that whole system of checks and balances to kind of keep them doing the job that they're supposed to be doing, if that kind of makes sense.
Right. So what we're seeing with the shadow dockets and what young people and, our audience should be paying attention to is this idea that the shadow docket is a useful tool, but it doesn't have constraints. And so right now we're trying to establish what the constraints on the shadow docket would be, right? Is it appropriately used in these cases? Or has it gone beyond its boundaries? And that's the thing about living in a society that values freedom, where we were talking about this recently in the office, that it's about attempting things and seeing if harm comes, right? And so it's not about being prescriptive, saying what we can do, but giving us freedom to make choices, freedom to experiment, and then evaluating the effects and then reining it in. And so what it sounds like is that the shadow docket has come under some scrutiny. And so there are questions about what this particular civic process should look like.
Exactly. And that's, again, the shadow docket is a term that was coined by a professor at the University of Chicago. I believe his name is William Bod. It used to be the orders docket, because again, you have somebody who will suffer irreparable harm and cannot wait for October to come for the Supreme Court. It exists for good reasons, but now it seems that their boundaries are being tested. And it's just an interesting look at the progression of the Supreme Court since, even Federalist 78, when Hamilton was writing about it, the first court, and how much it's changed. That's just it's an interesting question. And it's an interesting thing to look at as we move forward going into the next term, which actually starts here in a couple of weeks.
And you can keep an eye here at Bill of Rights Institute as the term starts. BRI has a ton of resources to help you with the Supreme Court on our websites. We have a fantastic Supreme Court playlist, which has over 40 different resources, hundreds of different activities. We have 30 plus Supreme Court DBQs, all of our homework help videos, our landmark Supreme Court cases pages, and of course, the programs and resources that are led by my great colleagues like Liz. So as we continue on in this great experiment of self-governance that is America, BRI is here to help you understand and teach the principles. So almost every week, I'll be here on Mondays talking through current opportunities. Hopefully my colleague Liz will be back to join me. Sign up on our website to get the emails. Remember, citizenship is hard work and we're here to help. So subscribe.